One last thing about age discrimination, and that is another issue that comes up in terms of age discrimination. Now, what we saw after the end of mandatory retirement, employers often wanted to encourage their older workers to retire. If you've been on the job 20 years, you're not doing anything that someone much younger couldn't already do. You're making a lot more money than someone younger, so we want to encourage you to retire. And one of the ways they did was to provide packages, incentives. We're going to give you a 2-year salary. We're going to give you 2 months' salary. However, in order to get that, you have to waive your right to an ADA claim. Meaning all we want from you is a document that says you won't sue us for age discrimination. You understand that you're entering into this voluntarily because you're going to get more money. Well, the problem is that people would sign those documents because they were afraid of not getting the money. The employer would say, look, you're going to get fired one way or the other. You might as well take some money with you on the way out the door. Here, sign this document giving up your right. Well, this became such a widespread problem that Congress acted, and the Older Workers Benefit Protection Act, the OWBPA, modified the ADEA to allow for early retirement incentive programs, but only if those programs met certain concerns. They set out in the act that the waiver must be knowing. You must know what it is that you've done. And in fact, the waiver has to contain certain phrases. There has to be an opportunity, for instance, for the employee to consult with their attorney. There must be a time period in which the employee can change his or her mind. So the OWBPA spells those factors out. And if the waiver doesn't match the requirements of the OWBPA, then it is not an effective waiver. It does not take away a person's right to bring a claim under the ADEA. In this case, Oubre versus Entergy Operations. Entergy Operations was a company based in Louisiana, energy company. This case wound up going all the way to Supreme Court on the theory that that Ms. Oubre had signed a waiver, had been paid money for signing the waiver, and then later discovered that the waiver was not effective because it violated the OWBPA. And she brought a case, and the employer says, fine, if you want to do that, but give us the money back. This case wound up going all the way to the Supreme Court, and the court said, look, if you require this person to sign a non-effective waiver, then you're responsible for any money you lost as a result of that unlawful act. Therefore, you don't get your money back, and Ms. Oubre retains her age discrimination claim. Remedies for age discrimination are also limited. Remember, the Civil Rights Act of 1991 allowed for the recovery of pain and suffering, compensation for non-economic injuries. ADA was not changed, and so therefore compensation for pain and suffering generally not available under the ADA. That means smaller damage awards and much more likely that that you are unable to find a lawyer because there's much less. Instead, you're limited to front pay or back pay and possibly reinstatement. So in conclusion, what do we know? The Age Discrimination and Employment Act regulates age discrimination. That plaintiffs can prove their case through disparate treatment or disparate impact, knowing, however, that it's very hard to prove a disparate impact claim. And finally, there are other issues for management, specifically in terms of those early retirement incentive programs.